grant the thurs. Morning, Your Honor.
Good morning, Mr. Ragnan. Good morning, Ms. Douglas. How's
Good
everybody
morning.
today?
Well, how are you?
Good, thank you. All right, good morning over at the CJC.
Good morning, Judge. How are you?
Good, thank you. How are you?
I'm great.
Who do I have there with you?
This is Mr. Brandon Alonso.
Okay, and has Mr. Alonso met with counsel yet?
Yes, ma'am.
Okay, perfect, thank you. As soon as I get defense counsel in the Zoom courtroom, then we'll go ahead and get him arraigned.
Thank you.
What camera are we on now with DDC? Does anybody know? I'll never know which ones are working anymore. Camera 2 is working today. Nope. Try camera 3. Camera 3 it is. Hey, Tompkins, could you go and let defense counsel know that we're ready to begin, please? Everyone is present in the courtroom. Thank you. Thank you. Good morning.
Morning.
Mr. Reagan, are you only doing Ms. Cole or you? Your label says that you're only here for Tariah Cole
Oh, no,
today.
I'm
Are you
not.
only doing?
That's
Okay, okay.
let me fix.
All right, thank you. All right, are we ready on Mr. Alonso?
Got ready on Mr. Alonso, Judge. Yeah.
Okay, great, thank you. Okay, Mr. Alonso, please state your name.
Brandon Alonzo.
Thank you. Good morning, sir. All right,
Good
calling
morning.
case number, morning, calling case number 240-589-8301, people of the state of Michigan versus Brandon Alexander Alonso, counsel.
Good morning, Your Honor. Samuel A. Ragnan, P23-157 on behalf of the people. Good morning, Mr. Reagan.
Mr. Ragnan, it's a pleasure as always to see you. Good morning, Your Honor. May it please this honorable court. Good morning, you and your staff. Philip Reagan on behalf of Brandon Alonso. We would waive the formal reading stand mute. He has been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Positions as to bond, please.
Now, people are asking for a $50,000 personal bond in this matter. It is not assaultive, but there were a number of drugs that he had with him on 11/24/23. But Your Honor, he also has a second drug case that is pending. Two counts again. That was from 130. He's bound over on 130/24 to Third Circuit. So, he's got two of these cases. 2 counts on one and 3 on another. So we're asking for a personal bond.
No
Thank you.
objection. No objection.
Thank you, counsel. Your request is for personal, not nominal.
Yes, Judge.
All right, thank you. Right, the bond will be set at $50,000 personal. Sir, you're not to purchase or possess any illegal substances during the course of your bond. That includes prescription drugs for which you do not personally have a prescription. Your next court date is going to be December 12th for your probable cause conference. December 19th is the date set for your preliminary examination. They're both set in front of Judge Jefferson. You are also not to drive unless you have a valid driver's license, okay?
Yes.
All right, thank you. You can let them know that you're all done.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Yeah, I also want to mention, Mr. Reagan, it's nice that you finally decided to face me instead of hiding behind the screen. Thank you.
Okay, well, I'm here. I'm here. I'm here.
All right. Let me listen over here. Here's that I have one more over at the CJC. Keep their screen up. Hello over at DDC. Can anyone hear me?
Yes, ma'am. Good morning.
Good morning.
Going right down the list?
I can hear you. Yes.
Okay.
Well, on Nathaniel, Mr. Reagan, has the capias on Nathaniel been addressed?
Not yet, Your Honor. We're still waiting for a response right now.
All right. I'm sorry, DDC. Can we pass Nathaniel till the end, please? Thank you. Good morning. What's your name, please?
John McQuaid.
Okay, Mr. McQuaid. Good morning. You've got some traffic misdemeanors where you missed court dates. When you miss those court dates, the judges assigned to those cases issued warrants and they set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You are being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors, so it's the maximum possible penalties up to 93 days in jail and or a $500 fine. Ticket P723267 alleges March 31st of 2021 at Glaston and Dexter that you did not have an operator's license and did not have insurance. Ticket U69301224 alleges May 13th of 2024 at an address on Joy Road, possession of narcotic paraphernalia. U611-72221 alleges September 16th of 2021 at an address on Joy Road, disorderly conduct, smoking near the gas pump. U596-75721, October 6th of 2021 at Homer and Claremont, possession of a knife in excess of that allowed by city ordinance. P1112437, September 12th of 2020 at Chicago and I-96, failure to display a valid operator's license, no insurance, unregistered vehicle. P1201867 alleging May 20th of 2021 at Joy Road in Dexter, driving while license suspended and no insurance. P1257040, October 7th of 2021 at Homer and Claremont, driving while license suspended, no insurance. P1367842, January 15th of 2023 at Joy and Dexter, disorderly conduct. P1514468, November 29th, 2023, Joy Road in Martindale, license suspended, unregistered vehicle. And P1564866, Joy Road in Dexter, loitering. On all of these, you do have personal bonds, and your next court date is going to be a pretrial, January the 10th of 2025 in front of Judge Wagner. Now calling case number 240-608-3701, people of the state of Michigan versus John McQuay. Counsel.
Samuel A. Ragland for the people, Your Honor.
Bring it on behalf of Mr. McQuay, Your Honor.
I'm sorry, did you say we're waiving formal reading and standing mute?
Correct, Your Honor.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Arguments as to bond, please.
Now, this is a reissue. This case was dismissed previously because the complaining witness was an hour late for court and the judge and prosecutor dismissed it. So it's been reissued. The bond at that time was $250,000 personal bond. It's a very serious incident, Your Honor. The defendant and the victim got into an argument at a gas station.
Well, I mean, I've read it, Mr. Ragland. So you're saying it's a reissue. It was a personal bond before. Sounds like he showed up for court, but complainant didn't. Is that what happened?
Correct. I didn't know if you had read it. $250,000 personal bond. We'll ask you for it again. Thank you.
Okay. All right. Thank you.
Thank you.
Mr. Reagan.
There's no objection. I know you probably read.
I did. Any other bond conditions that were imposed previously that you are requesting reimposed, Mr. Ragland?
I do want him obviously not to have any contact with the complaining witness, Mr. Marcus Bryant, but also not to go back to that gas station at Dexter and Joy Road where this incident occurred. I think, yes.
Okay.
Thank you.
All right. Thank you. Okay. Mr. McQuay, your bond is set at $250,000 personal. You are not to return to the gas station where this is alleged to have occurred, and you are not to have or attempt any contact with the complainant. That includes verbal contact, written contact, contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. Next court dates, December 12th for probable cause conference, December 19th for preliminary examination. Both are scheduled in front of Judge Giles. You are also not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Okay. Thank you.
Thank you.
All right, are we ready on our, on Mr. Miller? We are. Okay, thank you. Mr. Miller, come on up, please.
Your Honor, is it okay if Mr. Miller sits up here?
Absolutely.
Thank you.
How you doing?
At the
Raymond
BDC, what
Conley?
is? Raymond Conley. Okay, Mr. Conley, good morning.
Good
Calling
morning.
case number 240-608-2001. People of the state of Michigan versus Raymond Conley. Counsel.
Jennifer Douglas for the people, P72748.
Philip Reagan on behalf of Mr. Conley, Your Honor, waive the reading, stand mute. He's been advised of his rights.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. This is possession by prohibited person and felony firearm. Positions as to bond, please.
Your Honor, Mr. Conley, the people wouldn't object to a $50,000 personal bond in that Mr. Conley is not accused of trying to shoot somebody, although there were allegations of a firearm being discharged. Your Honor, he does have some priors, which, Your Honor, is why he's charged with possession by prohibited person, but for some reason I do not know or understand. There's no have notice, Your Honor. So just so the court knows what his priors are. He had 2010 ordinance violation of RNO, a 2013 HIDA home invasion second, which he did successfully complete, but then he also had another 2013, not HIDA, just a regular 2013 home invasion second, larceny from a person, larceny in a building, and then he had a 2013 home invasion second, and then he had a 2013 robbery, unarmed assault with a great bodily harm causing, or assault with great bodily harm, less than death, Your Honor. He was discharged parole August 23rd, 24. So while we do find that concerning, here he's not accused of trying to assault anyone, Your Honor. So I'm not going to object to a personal, but I'm asking for that higher personal bond, Your Honor.
No objection.
Thank you, Ms. Douglas. Thank you. Ms. Douglas, do those priors have the same, all have the same conviction date or alleged offense
No,
date?
Your Honor. I checked. Those are all different cases. Those are all different cases.
All right. All right, your request is for $50,000 personal. All right.
I would also ask for no
Then-
contact, even though it's not charged assaultively. I would ask for no contact with
All right, thank you,
Octavius
Mr.
Slayton.
You are not to, who's our no contact going to be with?
Octavia Slayton.
Thank you. All right. You are not to have or attempt any contact with Octavia Slayton until a judge says otherwise. That includes written contact, verbal contact, contact through social media, or third parties, okay? Any attempted contact would be considered a violation of the conditions of your bond. You're also not to purchase or possess any firearms or other dangerous weapons during the course of your bond, which is set at $50,000 personal. Next court date is going to be December 12th for probable cause conference, December 19th for preliminary examination. Those are both going to occur in front of Judge Giles. All right?
Thank you, Judge.
Okay. Thank you. All right, Mr. Miller. Mr. Miller, just state your name, please. You don't need to stand up.
Nathaniel Miller.
Thank you. Calling case number 240-454-8701. People of the state of Michigan versus Nathaniel Miller. Counsel.
Jennifer Douglas for the people, P72748.
Good morning, Your Honor. Just checking number 8179 on behalf of Mr. Miller, who is formal reading, understands his constitutional rights and stands in you.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on your client's behalf. Looks like this is a count of OWI. Positions as to bond, please.
Your Honor, since this is a misdemeanor OWI and it dates back to 2022, Your Honor, I'm not going to ask for a money bond or a tether. If it was more recent, then I might. But Your Honor, for Mr. Miller, we would not object to a $25,000 personal. We would ask for an order of no alcohol during the pendency of the case, though.
All right. What was the amount of the personal you were requesting?
$25,000 personal.
Thank you. All right. Attorney Shack.
Nothing pending, lifelong resident, has family support, turned himself in, Your Honor, and we don't have any objections to that.
All right. Thank you. All right. Given that I'm not seeing any flight risk, given that this is charged as a first-time misdemeanor, not going to see this as an overall danger to the community, bond will be set at $25,000 personal. Sir, no drinking during the course of your bond or until a judge says otherwise, okay? Next court date. Next court date is going to be December the 18th in front of Judge Bryant for pretrial. Thank you, Mr. Miller.
Thank you.
Mhm. All right, one moment at DDC, please.
Brandon Dean.
Okay, thank you. Good morning. Mr. Dean, you have a number of traffic misdemeanors where you missed court dates. When you missed your court dates, the judges assigned to those cases issued warrants and they set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You are being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney represent you on the tickets. If you cannot afford an attorney, one will be provided for you on or before your next court date. These are all misdemeanors, which the maximum possible penalty is up to 93 days in jail and or a $500 fine. Excuse me. Ticket number P1001717 alleges June 17th of 2019 at West Grand and Linwood driving while license suspended. I am presuming defense counsel is aware of the capias in this case. I'm going to go through the tickets and then we'll address that. Ticket number P1052006 alleging December 30th of 2019 at eastbound Davis and Joseph Compound, no driver's license. P1163319, March 1st, 2021, North Green and West Verner, improper license. P1238701, August 14th of 2021, 7 Mile and Gilchrist, license suspended, no insurance. V132635523, alleging October 28th of 2023 at Iris and Orange Lawn, illegal dumping. Ticket SP 12467831, alleging September 7th of 2021 at Joy in Indiana, license suspended, repeat offender. 194786561, alleging April 14th of 2019 at Nebraska and Lawton, no operator's license on person. 162115341, alleging October 24th of 2016 at Tireman and Hayden, no operator's license on person. 135945482, September 5th of 2013, Grand Boulevard and near Grand River, no insurance. 135945481, alleging September 5th of 2013 at West Grand Boulevard near Grand River. This one, no operator's license on person. 133445291, alleging May 24th, 2013 at an address on Ferry Park and 14th, driving while license not valid. 115929872, August 18th of 2011 at Warren and Southfield Service Drive, no insurance. Also on that same ticket, count one is no valid license. Then we've got ticket number 0854507771, September 10th of 2008, Grand River and Temple, failure to display valid operator's license. X3061786, alleging July 26th of 2017 at eastbound, I think this is I-96 in Grand River, no operator's license, no insurance on registered vehicle. Actually, I need to look at this ticket. Okay, this ticket is actually dismissed due to deficiencies on the face of the ticket. There is no I-9 freeway, and that is how the ticket is listed. Therefore, there's no ability to advise defendant of the location where this is alleged to have occurred. That one is dismissed due to errors. P40119, 977, August 13th of 2015 at Mansfield and Diversey. Driving while licensed, not valid, no insurance, unregistered vehicle. Then P160295, alleging July 16th, 2024 at Chicago and Prairie, license not valid. P12688481, alleging January 8th of 2022 at Greenfield and Vassar, license suspended and no insurance. Sir, on all of these, you do have the same court date and the same judge. You're scheduled for pretrial January 9th in front of Judge Sherman. All right. One moment, please. Madam Clerk, I'm going to hand you the stack of tickets. This one needs to be dismissed due to errors. Please just make sure, because it's a large stack, that that one actually does get dismissed. Thank you. Right. Now calling case number 210-565-5701, People of the State of Michigan versus Brandon Dean.
Samuel A. Ragnan for the people, Your Honor.
Your Honor, Philip Reagan on behalf of Mr. Dean, because we haven't heard back yet on the Capias motion. We're still waiting for a response, Your Honor.
All right. Thank
Your
you.
Honor.
Would you like me? Yes.
I apologize. People are not to be appearing on this because it's a Capias felony case, so we do not appear on this.
Thank you. All right, Mr. Reagan, would you like me to pass the case, or do you want me to go ahead and set bond as is right now?
Could you pass it briefly, Your Honor?
All right, thank you. DDC, we're going to briefly pass. Mr. Dean will need to recall due to the KPS. But let's get ahead of the next one, Mr. Reagan, on Brown, KPS.
Brown.
This one's a misdemeanor. I can deal with that. This one's a misdemeanor. I just want to make sure, because
Two, I think, Judge.
There you are.
Hi, sir. Okay, Mr. Brown, good morning. One moment, please. Okay, Mr. Brown. Calling case number 210-448-1501, People of the State of Michigan versus Larry Gerard Brown, counsel.
Jennifer Douglas for the people, P72748.
And Philip Reagan on behalf of Mr. Larry Brown, Your Honor, waiting for a written stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. KPS is set at 10% of $100. Looks like it might be the second one. Positions as to bond, please.
Your Honor, on Mr. Brown, the people would be asking for a tether at this time. It does appear that he has had multiple prior failures to appear, Your Honor, with a failure to appear October 17th, 2022. That was rescheduled. I'm sorry. Failure to appear October 17th, 2022. He was arraigned on the bench warrant April 13th of 23, and then he failed to appear for pretrial June 5th, 2023. That was rescheduled to July 10th of 23, and then he failed to appear for that. So, Your Honor, it's been almost a year and a half at this point since he appeared. His priors include a 2006 bank robbery, a 2015 GBH FIPFF case, Your Honor. In this case, Mr. Brown allegedly admitted pulling a knife at some point, Your Honor. And given the multiple failures to appear, we believe that a tether would ensure that he would appear for court right now. It does look like he has a pending case. And that is, and I believe that I did, in fact, email defense counsel about Mr. Brown's pending case. He just got charged for probation January 26th of 2024. for retail fraud first and possession of a narcotic less than 25 grams. That was, I think, out of Oakland County. His pending Sixth Circuit case is 23-284727-FH, where he's charged with fleeing and eluding third degree and retail fraud second degree. Your Honor, based on the register of actions in that case, it looks like he capious from trial and then got arraigned on that bench warrant November 26 to 24. So, Your Honor, he does have a history of failing to appear. He's got this other case going on. So we are asking for a tether. We believe that that would be more effective than a 10% or a $10 bond.
Did Oakland County put him on a tether for missing that November 6th trial date?
No, Your Honor, they gave him a bond of $5,000, 10%.
Okay, thank you. All right, Mr. Reagan.
Judge, I note that he has other stuff going on, other cases, other places. This case is from 2020. It's non-assaultive, MDP, less than 1,000. It's a misdemeanor. Judge, I'm asking for the personal. Habeas bond set $100. It looks like this was the first case in this case. Now, he may have had some other cases.
Hold on, because I've got an A and B in this case,
Yeah,
and you just
that's what
said
I have.
MDP, and I've got more than one capias in this case. I've got two.
Judge, is this Larry Brown? I apologize.
Yes.
I'm sorry, I apologize. Judge, this is charged with A and B. I have a different sheet, sir. So I am, I'm requesting, Your Honor, and I want to make sure this is the actual right case. What is the bond that you have? I'm sorry, Judge, on this case, and I apologize.
10% of $10, $100, 10%.
Oh, okay. So what I am asking for respectfully, Judge, is the $10 bond, Judge. When the capias came about, there wasn't a tether component added with the $10. So I'm just asking, I think the judge's intent was to maybe the $10, Judge, but to have some type of bond, but because of it's an A and B, Judge, but I'm asking for personal bond, Judge.
What's going on with the ability to, do you know, Mr. Reagan, or does anybody have an update on what's going on with the ability to post bonds and how long that's taking at this time?
Judge, I know my client's on disability, doesn't have any money, or, he possibly posted $10, Judge. So.
No, I'm not asking about your client, Mr. Reagan. I'm asking about the county's process at this time in terms of being able to post bond, get it credited, get out. What are we, from the hacking, are we recovered? What's going on with the ability of defendants to get out?
Well, Judge, I'm hoping that we are recovered from the hacking. I don't know specifically. I obviously, I think it's a case by case. I don't know of any major problems that we're having like we did previously. I would note that some that have come to my attention that people could not post bond, but nothing like what we were dealing with previously, to my knowledge.
Is this a case where you guys would be working with Mr. Brown to make sure that he appears for the court because it's a misdemeanor? Are you guys working with him through the pendency of the case?
Absolutely, Your Honor. I'm going to get this case resolved with him. 73 years of age, he's on disability. We want to get this resolved and over with. So we'll be working closely with Mr. Brown.
All right. I mean, I spotlighted Mr. Brown for a minute because, quite frankly, he is contrary to all the research that we have on brain development and when people stop committing crimes. Stop. You don't need to talk right now. At your age, I do not want to keep you in the jail for the time that it would take to put a tether on you, because I don't know how well the jail is equipped to deal with that. And because I don't see you as a danger to the community without a tether, I don't want to do that. But, you got to come to court in Oakland County and in Wayne County, in Detroit. We want you for court too. All right. And somebody's going to get set up if you keep not coming to court. And they're going to hold you in there, and that's not where you want to be sitting. Because Judge Bryant didn't order a tether, And because Oakland County didn't order a tether for missing trial, which I consider much more important, I'm not going to order the tether here. I'm going to trust the judgment of those judges in terms of whether or not a tether is necessary. At the same time, I do not want Mr. Brown, because I don't see him as a danger to the community, getting stuck in the jail, even if he can post $10 just because of some of the issues that have been going on there, because I don't think it's necessary to protect the community. So I'm going to go ahead and convert this, but I'm going to make it a $1,000 personal bond, sir. So, you know, it's not just at $100 anymore. It's now at $1,000. You have to show up for court. If you need to work with someone in order to get some help with appearing by Zoom, talk to the attorney so they can help you with using whatever you need to use to appear for court by Zoom. Next court date, December 18th. December 18th in front of Judge Bryant, $1,000 personal. So you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. And you're to have no contact or attempted contact with the complainant, Mr. Clay. That includes contact through third parties or by social media. All right. Any attempted contact would be considered a violation of the conditions of the bond. Thank you.
Thank you, Judge.
All right.
Thank you, Judge.
I'm sorry, I couldn't hear what. Mario Tedford. Okay, thank you, Mr. Tedford. Calling case number 200-449-7901. People of the state of Michigan versus Mario Tedford. Counsel.
Jennifer Douglas for the people, P72748.
Yeah, Mr. Tedford, Your Honor, with the reading stand mute, he's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, on Mr. Tedford, the people actually wouldn't object to this being converted from a 510% KPS bond to a 500 personal. Mr. Tedford had two cases going on at the same time. One was a felony and was bound over. I did look at the register of actions on that, and he appeared for court on that. So there might have been some confusion on his part about the two different cases going on, Your Honor, because they were going on at the same time. So he did appear in the other cases. I did not see any probation violations in that other case, and he's been on probation for some time on that other case since 2023. So I think there's just some confusion here, so I'm not going to object to that becoming a 500 personal.
Thank you. You're muted, Mr. Reagan.
No objection, Your Honor.
Thank you. All right, this is charged as a misdemeanor A and B back from looks like 2000. We'll go ahead and impose a, or is it 2020? I'm sorry. Just looking at the case number. The date of the offense.
2020.
120. Okay, thank you. Yeah, looks like the last bond that I imposed was $2,000, 10%. There was probably, maybe there was a KPS there at the time, but at any rate, we will convert this to a $500 personal bond. Make sure you don't miss your next court date. Next court date is going to be December 18th in front of Judge Bryant. No contact with the complainant. That includes through third parties or social media. All right, December 18th, Judge Bryant for pretrial. Thank you. 500 personal.
A personal bond, you take a check. Explain it, come on, Howard. Come on, Howard.
Good morning. Mr. Hollis, good morning. Calling case number 230-444-9901. people of the state of Michigan versus Kenneth Hollis. Counsel.
Samuel A. Ragland for the people, Your Honor.
Deliberating on behalf of Mr. Hollis, waive the reading, stand mute, he's been advised of his rights, Judge.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. KPS here is set at $5,000 cash surety. Positions as to bond from the people.
Your Honor, we'd have no problem reducing that bond. He's got 3 capiases, as I see it, 12624, where he's also added a tether of 91624, 92324. So he doesn't want to show up apparently, and he's on parole as well. So I don't understand why he doesn't want to abide. But the thing is that we're available. We would have no problem with the tether monitoring. That's all. Get him to show up to court. This is a 2021 case. I don't think he's a danger, but I think he might not show up again. And we'll just happy to reduce that to $25,000 personal bond. Unless Mr. Reagan's going to follow him, if you're going to follow him and represent him, and keep in touch with him, then I'll waive the tether.
Okay, thank you.
Because we are going to do our best to keep up with Mr. Hollis. I'm going to be honest, Judge, he's not have a place to live right now. So that's been the main issue. He's 65. Mr. Ragland stated he's on parole. He received that set aside, but he was living somewhere. He needs some type of shelter or something to go to. So that's what we've been trying to recommend and get to. This is the older case from 2021. Want to just get it resolved. So I'm asking for the personal bond, Judge. Obviously, I don't want to tell it, but I want to be forthright with the court about what the living situation is at this time.
Are you asking me to order his release only to a shelter?
Well, I'm asking that he be released, Judge. Now,
Okay.
Given that, I'm asking, yeah.
All right, thank you. Do you feel like you have the ability to keep in touch with Mr. Hollis?
Judge, we do have a phone number for Mr. Hollis in which he checks that we will be able to get in contact. We also have his email address, in which we should do emails as well to give people information about their cases, when to come to court, how to come to court, Zoom in, when to Zoom in. So we have his email information and his phone number, to a family member that we want to make sure we keep.
You know what? And this is now, I'm going to need to double check because this is at this point a Judge King case. And so I want to double check that he has in fact given this court the authority to reduce his bond.
That's just a judge, just one to Judge Bryant, I think.
It's going back to Judge Bryant now.
Yeah.
Judge Jones. Okay, well then if it's Judge Jones, then that's okay. If it's a Judge Jones case at this point, that's okay then. Looks like King signed is the one who set the KPS. Mr. Hollis, you have to come to court. I mean, for the same reasons. I don't want to have to keep you in jail when I don't see you as a danger to the community just because you're not coming to court. You have to come to court and get it over with. Bond is set at $5,000 personal. Next court date, December 17th for pretrial in front of Judge Jones. No contact with the complainant. That includes through third parties and social media. Same thing, if I put a tether on you, you're going to sit there for a couple of weeks in the jail. And then if you don't have a place to be tethered to, you could sit in the jail forever until the case is resolved. So I'm putting it in your hands. You have to come to court, okay? You have to show up, either in person or by Zoom, however they want you. December 17th, Judge Jones.
Thank you, Your Honor.
Okay.
December 17th, right?
Yes, what did I just say? That's what I thought I said.
September 17th. I'm here still.
Oh, goodness, no, December 17th, thank you. Hi, what's your name, please?
Ragland got me nervous.
What's your name? Mr. Garrison, okay, thank you. Right, calling case number 240-608-7601, people of the state of Michigan versus Caleb Garrison. Looks like we've got a count of receiving and concealing stolen motor vehicle. Counsel, appearances.
Jennifer Duggs for the people, P72748.
Deliberated on behalf of Mr. Garrison, Your Honor. Waive the formal reading. Stamp duty has been advised.
Thank you. Counsel, the court notes formal reading has been waived. Interest in not guilty plea on your client's behalf. Looks like we also have an R&O here. Ms. Douglas, positions as to bond.
Your Honor, Mr. Garrison, the people wouldn't object to a $35,000 personal, but I am asking for tether house arrest for the following reasons. Mr. Garrison has a lot going on in his life right now. He's currently on high to probation out of Third Circuit Court. He's been on high to probation since May 9th of 2023 for R&O causing injury and fleeing fourth degree. So we have a case where he's admitted to fleeing from the police. Here we have, in this case, the current case, we have the allegation that first he left the scene after a crash that was so bad that it disabled the vehicle he was in. And it turned out that vehicle was a stolen vehicle. That when police realized it was a stolen vehicle and that he had a full extradition warrant out of Ohio and they tried to arrest him, he then tries to still push his way out of the police car, and the police had to have a struggle to get him arrested, Your Honor. So we do have concerns about flight, and that is why we're asking for that tether house arrest. I would also point out that the lien shows that Mr. Garrison's license is suspended, although it also shows that it is expired in February of this year. So driving a stolen vehicle that he later allegedly says he kind of knew was stolen because he started it with a USB and then trying to flee from that scene 2 different times. Your Honor, I would also point out that reference to the Ohio warrant, I was able to track that case down, Your Honor, and I did send the information I did email defense counsel about that. That is a case where he pled to 1 count of unlawful sexual conduct with a minor, a 4th degree felony, and public indecency in Ohio. That's case number 2022 CR 0544. The Ohio Department of Corrections website, where you look up an offender, is showing that Mr. Garrison is that he has absconded from parole on that case, Your Honor. And that's what that full extradition warrant is on that CSC case. So, Your Honor, we do at this point think that there's a flight issue, and we're asking for tether house arrest.
So, Judge, I would agree that Mr. Garrison's 21, a lot going on. He works at McDonald's, though, every day, Judge. You know, doesn't have any kids, Judge. He's receiving and concealing property, receiving and concealing motor vehicles. From my understanding, he bought a car, but I do understand there's some other situations within the report that kind of make it a little bit sketchy based on what the report says. Now, Mr. Garrison tells us a little different story. But regardless, Judge, Mr. Douglas said he's on parole. You'll have to deal with that issue. That's not something that we'll deal with. I am asking for the personal bond, and she is asking for it, but I don't necessarily think the tether is necessary. If you tell him to come to court, I don't know about he has other matters going on in other places that he's going to have to deal with. But in terms of us, I'm just asking for the personal bond, Judge, because it's not technically kind of non-assault. That's just with the RNC, but I do know there's an R&O component.
All right, thank you. You know, the bond's going to be set at $35,000 personal, but quite frankly, I think GPS with house arrest is the right stance here. We've got absconder status out of Ohio. We've got a previous conviction that mirrors pretty closely the charges here, both alleging attempted flight from police. Again, you know, bolstering the argument that there is a possible flight risk here. The absconder status out of another state, that being Ohio, again, pointing to flight risk. So bond is set at $35,000 personal. GPS, house arrest, tether must be fitted before he leaves the jail. Next court dates, December 12th for probable cause conference, December 18th for preliminary examination, both in front of Judge Jefferson. Thank you.
Thank you, Your Honor.
What's your name, please?
Jackson.
All right, Mr. Jackson, good morning. You've got a couple of traffic misdemeanors where you missed your court dates. When you missed your court dates, the judges assigned to those cases issued warrants and set bonds. I'm going to set the warrants aside today and give you personal bonds on the tickets. You do have the right to remain silent. You're being recorded. Anything you say could be used against you in the future. You also have the right to have an attorney who represents you on the tickets. If you can't afford an attorney, one will be provided for you on or before your next court date. These are misdemeanors to which the maximum possible penalty is up to 93 days in jail and or a $500 fine. One moment, please. All right. Ticket number P11505553 alleges March 1st of 2021 at Hubble and Finkel, unregistered vehicle, no insurance, and no valid license. P1231461 alleges July 28th of 2021 at Fullerton and Livernois, license suspended and no insurance. P1250055 alleges September 14th of 2021 at Jeffries and Littlefield, driving while license suspended. On all of these, you do have personal bonds, and your next court date is going to be a pretrial January 10th in front of Judge Williams.
Okay.
Now calling case number 110-602-0701, People of the State of Michigan versus Javante Jackson. Counsel.
Samuel A. Reagan for the people.
Reagan, on behalf of Mr. Jackson, waive the reading. He's been advised of his rights.
Thank you, counsel. Court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. This is a misdemeanor A and B charge from 2011. I don't see any capiases in the file. Positions as to bond.
People are asking for a $1,000 personal bond.
No objection, Judge.
Thank you. All right. Bond will be set at $1,000 personal. In terms of the no contact, this is a 2011 case, Mr. Reagan. I've got a no contact with complainant. Is there an issue there?
There's no issue. He hasn't seen it in over 10 years.
Okay, very good. All right. The bond is going to be set at $1,000 personal. Sir, you are not to have any contact or attempted contact with the complainant in this case. That means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of your bond. Your next court date is going to be a pretrial in front of Judge Jones on December 17th. Thank you.
Thank you, Judge.
All right, over at the CJC, good morning.
Good morning, Your Honor. For you today, I have Mr. Jalen Jackson, who has already spoken to attorney Mr. Reagan earlier this morning.
Thank you. All right, let's go ahead and call these two together then. Mr. Jackson, please state your name.
I'm Jackson.
Do it one more time.
Jalen Tayon Jackson.
Thank you. Calling case number 240-460-4501 and case number 240-460-6901, both People versus Jalen Jackson, both charged as retail fraud, the first case in the third degree, the second case in the second degree. Appearances, please.
Jennifer Douglas for the People, P72748.
Reagan, on behalf of Mr. Jackson, waive the reading. He's been advised of his rights.
Thank you, counsel. Court notes formal reading has been waived. It enters a not guilty plea on Mr. Jackson's behalf. Positions as to bond, please.
Your Honor, Mr. Jackson has a lot going on himself. The people are somewhat at a loss. These are retail fraud cases. However, Mr. Jackson, based on the bonds in his other cases, was supposed to have been at least looking at the register of actions on tether house arrest with work only at the time of these alleged offenses. So it's a little unclear how that could have taken place, but it also makes it unclear whether tether would be helpful here, since how these are misdemeanors. Your Honor, he's currently on bond in multiple cases. He's on bond for an unarmed robbery that's at Third Circuit right now, case number 24-006390-01. Your Honor, the date of offense there being October 11th to 24. That register of actions indicates that he's on 5,000 personal with a tether, Your Honor. And then he's got another case that's still at 36th District Court, Your Honor, and that is 24-05737-101, a UDAA case where he had a few failures to appear, a failure to appear for exam on June 13th to 24. He's arraigned on that bench warrant July 16th to 24 and given a personal. Then he failed to appear for exam August 14th to 24. He was arraigned on that bench warrant August 27th to 24 and given a money bond, but at redetermination on August 29th to 24, Judge Williams reduced that to 15,000 personal with tether house arrest work only. So then he was not at court for his for PCC on September 30th, 24, but the attorney wasn't there either. And so that was in front of Judge Taylor when apparently he still hadn't shown up to the court. By October 9th to 24, she issued an arrest warrant, a bench warrant, but set the bond at 5,000 personal. She did not put the tether back on, but he's supposed to have been on tether house arrest at this point that he's allegedly committing these offenses. Even with the armed robbery, he's supposed to at least be on tether. So I'm not sure what happened there for him to be at these stores, allegedly to be stealing things, Your Honor. Normally in this sort of charges, I would ask for a tether. I don't know if somebody
All
took
right,
it off by
let me see if I can get straight on what happened in the UDAA case. Let's just talk about that one first. I thought what you said was December 27th of what, 2023? I thought you said 2024, but that's not possible. So when did Judge Williams order the 50,000 personal with tether house arrest work only?
That's 15,000 personal with tether house arrest. That was August 20. I'm sorry, I misspoke. August 27th of 2024.
August 27th of 24, Judge Williams puts him on a house arrest tether, but allows work personal bond. Judge
Yes.
Taylor, when issues the 5,000 personal without a tether?
That's August 9th of 24. But he also has the unarmed robbery.
I know, just,
Oh, sorry,
I need to,
sorry.
I'm just trying, okay. So Judge Taylor, before Judge Williams then, because you said Judge Williams was August 27th of 2024. So is that right?
Judge
When did
Taylor,
Judge Williams order the tether with house arrest work only?
that was August 29th of 2024. Judge Williams ordered that.
Okay, so that's August 29th of 2024. When
Yes.
did Judge Taylor issue her personal bond?
October 9th, 2024.
Okay, and she did not order a tether, correct?
That's correct.
All right, so that's why he's not on a tether in the UDAA. Now, unarmed robbery.
Yes, Your Honor.
What I heard was October 11th, 2024, $5,000 personal bond there. Did the judge in that case order a tether?
He was arraigned on that case October 25th of 2024.
Okay. That was a 5,000 personal. Was a tether ordered then?
Yes, Your Honor. Based on the
Okay.
register of
And
actions.
what were the terms of the tether on that case?
Your Honor, that I don't know because I looked it up on Odyssey. Let me look it up on 36th
Okay.
District Court right quick.
This is on Mr. Jalen Jackson.
Armed robbery case, 36.
Case was scheduled for this morning, a probable cause. I don't see that.
Okay, they're telling me that that was just scheduled for probable cause conference this morning and that they're not seeing anything about a tether having been ordered in that case.
No, Your Honor, there is a case that's case number 24-006390. That's at Third Circuit Court.
Okay,
It's an unarmed robbery. But,
Okay,
you know, that
it
might
was-
not have been Detroit. Let me see what city that was out of but that's in front of Judge Deborah Thomas, or sorry, Judge John Gillis.
okay. All right, let's hear from defense counsel.
And Judge, I know he has some prior cases that were dismissed. He works at McDonald's every day, so on 75. But I know the only case I knew of was the UDAA case, Judge, in which he had a personal tether on that. I didn't know about the unarmed robbery case. I didn't see that in the system. I don't know why it's not in our system. Mr. Douglas says it's in the Third Circuit system. I don't know why it's not in our system. But Judge, I would ask for personal bond. These are not faulted. That's a request, Judge, just a personal bond for these retail fraud.
Thank you. Ms. Douglas, has there been any failure to appear since, in the UDAA since Judge Taylor issued the personal bond case there? Personal bond there?
He hadn't been arraigned on that until, let me see when he got arraigned on that.
Well, I mean, he was arraigned at some point because we had a $50,000 personal bond that was set by Judge Williams, and there was a personal bond given on it before that. Judge Williams put the tether on. Then Judge Taylor had a personal bond with no tether. So, I mean, he was arraigned. So what I'm asking is, since Judge Taylor put the personal bond on the UDAA, do you see any failures to appear there?
That's what I'm saying. I'm not sure he was back in court until now or recently on that. I think he just got arraigned on that one. Arraigned on the bench warrant on that one recently.
Okay.
I gotta find it again.
His bond.
Okay, that's okay then.
Now, he had a case today for the UDAA and Judge Taylor today, this morning. He had a problem.
I'm gonna, hold on, DDC. I'm gonna put you in the waiting room for a second because I'm getting feedback. I'll be right back with you.
This is November 27th to 24 is when he was arraigned on that bench warrant. So that's after the date of offense.
Okay, and then he was scheduled for pretrial on that one today, or a probable cause today.
Correct.
Okay.
12/12 PCC today, correct.
Okay, all right. And she didn't have him on a tether. Are you aware of whether or not that probable cause conference took place today?
Mr. Jackson, did you go see Judge Taylor this morning?
No.
Yeah, so I'm wondering if this 5,000 is a capious. I'm looking in the system, it says, well, it's 5,000 personal, 5,000 personal. Nope. It's 5,000. She said a 5,000 personal.
All right, thank you. Okay, all right. All right, these are both retail fraud cases. You know, they don't present a dangerousness to the community. You know, in terms of prior convictions, I'm not hearing anything that's dangerous to the community. I've got an unarmed robbery that's ongoing, but it's not a conviction at this time. And I don't know what's going on with whether or not he's on a tether there. I'm going to go ahead because these are retail frauds, and I'm going to set these at $5,000 personal. Right. Next court dates on these are going to be December 18th in front of Judge Bryant, December 18th in front of Judge Bryant. Sir, you're not to go back to the Walgreens where this is alleged to have occurred, and you're not to go back to the Sunoco gas station where this is alleged to have occurred. Okay?
Yes, Your Honor.
All right, thank you. Officer over at the CJC.
Yes, Your Honor.
It appears that he is also supposed to be in front of Judge Taylor this morning for a probable cause conference. I don't know if you guys have that, but I don't want him to get a capious, you know, issued.
I will look into it, Your Honor. We do not have it on our docket for today, but that does not mean that he wasn't supposed to appear. I will look further into it.
Okay, thank you. Yeah, according to our records, he's supposed to be in front of Judge Taylor for probable cause today.
Cause Judge Taylor. No problem, Your Honor. Thank you for the information.
Thank you very much. Have a good day.
You as well.
Thank you.
All right, have a good day, sir. Thank you.
We're gonna sign, no, we're gonna sign into Judge Taylor, so if they want to.
Okay. Sorry about that. DDC, what's your name at the DDC, please?
Julian Bravocata.
Thank you. All right, calling case number 240-608-3501, People of the State of Michigan versus Julian Prabhupada, counsel.
Jennifer Douglas for the people, P72748.
Philip Reagan on behalf of Mr. Prada Power, Your Honor, waive the formal reading, stand mute. He's been advised of his rights.
Counsel, court notes formal hearing has been waived, enters a not guilty plea on your client's behalf. Offense date here is almost a year ago, January 2nd, 2023. Charges FA, FF, and A and B. Positions as to bond, please.
Your Honor, the people wouldn't object to a $75,000 personal bond. We would ask for no contact with the complaining witness or the address.
No objection, Your Honor.
All right, thank you. Sir, your bond is set at $75,000 personal. You are not to purchase or possess any firearms or other dangerous weapons during the course of your bond. You are also not to have any contact with the complainant in this case. That means no verbal contact, no written contact, no contact with third parties or social media. Any attempted contact would be considered a violation of the conditions of your bond. And counsel, no objection to a do not go to place of alleged place of offense.
No objection, Judge.
Thank you. Sir, you're also not to return to the location where this is alleged to have occurred during the course of this bond or until a judge says otherwise. Next court dates, December 12th for probable cause conference, December 19th for preliminary examination, both of those in front of Judge Taylor. Thank you.
Thank you.
Thank you.
Jamar Taylor.
Okay. Good morning, Mr. Taylor. Calling case number 240-608-7901. People of the state of Michigan versus Jermar Taylor. Counsel.
Samuel A. Ragnar for the people, Your Honor.
Philip Reagan on behalf of Mr. Taylor, Your Honor, waive the formal reading, stand mute. He's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Charge here has to do with possession of narcotics. Positions as to bond, please.
Well, people are asking for a $50,000 personal bond, even though we should probably be asking for something different. He is on parole. He's for 2 charges back in 2021 for controlled substance delivery, 50 grams. So he's on parole, and parole doesn't get he doesn't get discharged until August 6th of 2025. But it was a traffic stop, and they found drugs in the car that he was driving. So we think personal bond should be appropriate.
No
Thank
objection, Judge.
All right, thank you. Given that the prior convictions do not indicate an assaultive risk to the community, and I'm not seeing a failure to appear or flight risk here, bond will be set at $50,000 personal. Next court date is going to be December 12th for probable cause conference, December 19th for preliminary examination. Both of those are in front of Judge Giles. Mr. Taylor, you are not to purchase or possess any illegal substances during the course of your bond, including prescription drugs for which you do not personally have a prescription. Right? Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Can we go to the female side? That was the last male other than atheist, and then we can just check.
All right. Thank you. All right, they're not ready for the last 2 males, DDC, so we'll go over to the female side if that's okay, and then come back. Hopefully they'll have an answer on the KPS cases. Hello on the female side, DDC. We're here.
First up, Yeah, first up, Commissioner Jackson. Have a seat, Tanner. Say your full name.
All right, good morning, Ms. Bullock. Calling case number 240-594-2601, people of the state of Michigan versus Erica Jaleesa Bullock. Counsel.
Samuel A. Ragnan for the people, Your Honor.
We'll break it on behalf of Bullock, Your Honor, waive the reading stand. You has been advised of her rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Excuse me, positions as to bond.
Well, yeah, the people are asking for a $50,000 personal bond, but are also asking for a tether. And the reason with monetization, the reason for this, Your Honor, is that there was an argument involving the complaining witness and the defendant over their child that he had. The complaining witness then took the child, got in his vehicle and left, but she got in her truck and followed the vehicle. When the complaining witness came up to an intersection, he slowed down, and with that, he ran the back of his car and pushed him out into the intersection where he was struck by another car. Luckily, nobody got hurt or nobody got killed. When the police did arrive, she gets out of the car, okay, and has a taser in her arm with her. She's holding a taser, okay, which obviously she couldn't do. The police went to her vehicle and they observed the knife and brass knuckles on the passenger seat. So apparently she thought she was going to get into a fight with a number of people and hurt the father of her child with the child in the car. So I think she's a danger to the complaining witness. I think she's a danger to the public having these types of items with her in a vehicle, pushing a car into an intersection. She's lucky no one was killed. We will ask for a personal bond, but I think a tether is important. Thank you.
So let me ask you, Mr. Ragnan, I mean, all of that being said, yet the only charge I have here is possession of a taser.
I totally
No
agree.
felonious assault, no resisting and obstructing, no child abuse or endangerment, not a thing, except possession. I don't even have anything as a possession of brass knuckles, just a taser.
I know. Unfortunately, I didn't get to write it, so I don't know who did. But I agree that it's a serious, very serious matter. All right, thank you.
Okay.
Judge, I'm asking for a personal bond for possession of a taser. Allegedly, she turned herself into the 7th precinct. She informed us after all this happened. She found out about the warrant because this was something that happened allegedly back on September 13th. And now yesterday she went in and she works every day as a child. I don't think she's a flaw judge. I'm asking for personal bond.
Okay, thank you. I mean, there's age to the case. I don't have any information about any further incidents between the parties. This is charged solely as possession of a taser. I trust the prosecutor's office to make an assessment of what they think the chargeable offense is. And here, although there are descriptions of things that could constitute other offenses, there's been a choice not to charge any of that. The charge here is merely possession of a taser. So $50,000 personal. Ms. Bullock, you're not to purchase or possess any firearms or any other dangerous weapons during the course of your bond. That includes tasers, brass knuckles. You cannot possess those things, okay? I don't really know what else to do here, given the nature of the charges presented to the court.
No contact.
All right. Associated with what charge?
Taser, no contact with taser.
A taser is a dangerous
I
weapon.
get it. I was
taser.
considering, Mr. Ragnan, I know we're saying no contact. I was considering a no contact, but they have children in common. And this is alleged to have occurred in September. So I'm assuming that they've been engaging in child exchange since September. And I don't have any information that anything has gone wrong with respect to the child exchange. That's the reason I didn't address a no contact in the order, because there's a couple months age to the case. There's children in common. the way that this presents would be that those children have been continuously exchanged since that time. And if I don't have an ongoing issue and no charges with respect to an assault of the other party, the other parent, I just don't see the justification for it here, although I completely understand your argument based upon the description of the allegation. All right, $50,000 personal, no weapons. December 12th, probable cause conference, December 18th, preliminary examination, both in front of Judge Jefferson. Thank you.
Thank you. Yeah.
All right, good morning, Ms. Hadley. Calling case number 240-460-0701, people of the state of Michigan versus Quanisha Hadley. Counsel.
Family Ragnar for the people, Your Honor.
Philip Ray, Ms. Hadley, waive the reading, stand mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. Positions as to bond here, please.
Well, Your Honor, the people are asking for $25,000 personal bond. This case is from 2022, so I'm not going to ask for a tether or alcohol tether. I am concerned. I mean, she was blocking the exit way or entrance way to the freeway if she had fallen asleep. She blew point 23 and point 22. Another concern here is that she has a domestic violence case that's pending that was set for final pretrial conference yesterday. Prior domestic violence that she was convicted of, and I just thought I'd mention it for the record. That's all. Thank you.
All right, thank you.
No objection to the personal bond.
All right, thank you. All right, I don't have any prior OWIs. I'm not seeing any information about anything since 2022. So hopefully this was a wake-up call for Ms. Hadley. We'll go ahead and set bond at $25,000 personal. Next court date, December 18th, in front of Judge Bryant for pretrial. Ms. Hadley, you are not to drink during the course of your bond. All right, no drinking during the course of your bond, and no driving without a valid driver's license. Okay, thank you. I'm
Thank you, Your Honor.
That's all the females, Your Honor, get your mail side.
See you back on the male side.
So, Judge, we haven't had what
You're going in and out, Reagan. I can't hear you.
now, Judge. Oh, here, I just say, hold on one second. Hey, what's up? Judge, I have received copies of the motion, Judge, to reduce both bonds, one in part with a tether and one without a tether.
All right, thank you. We'll go ahead and get the cases called. You can place it on the record.